Good morning. Thank you for joining us and a very warm welcome to you. As the dust settles on yesterday's budget announcements, our expert panel is here to provide a high-level analysis of what the tax changes mean for affluent individuals, families, and their advisors. We'll also be picking up on some of the key themes that we covered in our recent national inheritance tax roadshows, and we will be discussing the opportunities for tax mitigation as part of ongoing estate planning. If you've got any questions for our panel, please do feel free to write to us in the Q&A channel, and we will come back to you after the session with an individual response. I'm delighted to introduce you to our expert panel, Ashley Hill, Penny Koga, Andrea Jones, and Naomi Neville. So Ashley, let's go to you first. This budget hit hard for high net worth and ultra high net worth individuals?
Thanks, Joanna. Great question for those of us who advise high net worths, ultra high net worths. Well, these measures, I think they stop short of wholesale reform. They clearly signal a move towards taxing wealth and passive income more aggressively. So for high net worth clients, the headline changes include, so we have a mansion tax, which was well mooted beforehand, which will come in from April 2028. It's basically an annual surcharge of £2,500 for properties over 2 million and £7,500 for those above 5 million. And it's payable alongside the council tax. So it's being collected via the council tax system, but the actual surcharge goes to government as opposed to local councils, which is interesting. Question around valuation. How do you value these properties? It's not on purchase price or anything like that. The valuation office agency, a government agency, is going to be going through a valuation exercise in 2026 to determine, to look for these properties and determine which ones are 2 million upwards to get them into the right bands. So another key change, April 2026, changes to income tax rates on dividends. Dividend rates will rise by 2 percentage points. So ordinary rate dividend payers will go from 8.75 to 10.75. The upper rate will go from 33.75 to 35.75. Interestingly, the additional rate remains at 39.35%. Not quite sure on the intention there. Maybe the business owners who take big dividends out, they're still going to be at 39.35 as opposed to having an additional 2% surcharge. And then from April 27, again, there's going to be 2% increases for property and savings income. So the bands will go from 20 to 22, 40 to 42%, and the top rate will go from 45% to 47%. Interestingly, these all income tax rises we have compared to CGT, that went up from 24% last October in the last budget. So there's clearly a thinking there, income versus capital as a planning idea. Cash ISA limits for under 65 savers. The cash element still got an overall cap of £20,000 per year, but the cash element will reduce to 12,000. So there's clearly an encouragement here for pushing towards equity investments, funds, etc. With that other £8,000. Business owners, CGT changes. I mentioned the rate stays the same. Business owners looking to sell their businesses, you may be aware of something called employee ownership trusts, and selling your business to basically an employee ownership trust where the employees own the company. That was fully exempt. Now they've reduced that exemption to a 50% relief. Some slight positive news, I guess, for investors. EIS, VCT, enterprise management incentives will expand to larger companies, potentially creating fresh opportunities for tax-efficient investment. Despite changes not being so good for VCT investors, with VCT income tax relief reducing from 30% to 20%. Interestingly, but no, EIS income tax relief is staying at 30%. So I'm not sure of the rationale for that, but I've seen there's VCT industry quite unhappy about it, making their investments less incentivized.
So how do these changes compare with the previous measures that we've seen targeting wealth, such as the non-dom reforms?
Well, I think the non-dom reforms were that was an elimination of a whole tax regime. which forced significant restructuring. These measures are focused on domestic wealth and recurring passive income streams, which are going to be taxed. They're incremental but broad-based, targeting property investment returns rather than residency status. So I'm not sure that these changes are, with the non-doms, a lot of our clients in their thousands left the UK on the back of those changes. I'm not sure these changes are necessarily going to, cause any more people to leave necessarily than already planning to. Uh, but no, the cumulative effect will be material, especially for those with significant property portfolios and dividend income. Particularly landlords who are, mortgaged heavily, and it's quite hard to make a return at the moment. They'll be deciding whether property is still a good investment or not, given they're now going to have to pay an extra 2% income tax. So I think while the measures are less disruptive than the non-dom overhaul, i.e. the thousands of departures from the UK, they will increase the effective tax burden for many high net worth individuals. So it's going to be really important for planning to mitigate these impacts. So they'll be thinking around, should I hold my investments via a company of some sort, family investment companies, personal investment companies, because the corporation tax rate is still 25%, and you can leave the income to grow in there if you don't extract it. And also thinking around, capital versus income. Should be going for capital growth, which will be taxed at 24% as opposed to income growth, but it just depends on people's circumstances, really.
Penny, the Chancellor announced a £2,000 annual cap on salary sacrifice for pensions from 2029. How significant is that change for high net worth individuals?
Yes, this is significant for high net worth individuals, but delaying the impact of the change until April 2029 does give employers and employees the opportunity to continue to benefit from this extremely valuable relief in the meantime. But it's also a benefit which disproportionately benefits higher earners, and introducing the cap won't impact any employee earning under £40,000 a year, where only the standard auto-enrolment pension contributions are being paid. This £40,000 salary limit is not indexed. As salaries should increase gradually over the next 4 years, this will bring more individuals outside the scope of pension salary sacrifice by the time the salary sacrifice cap starts to bite. For higher earners, pension salary sacrifice will be increasingly irrelevant.
So what should individuals and employers be thinking about now?
Well, there is time ahead of April 2029. So our advice will be for those who are still able to pay into their pensions to consider maxing out their contributions now. It is, of course, vital for individuals to seek financial advice ahead of doing so. This is to ensure the affordability of any plans to pay increased contributions and to maximise pension investment. It's also important that they bear in mind the significant changes announced last year, which will bring unused pension funds within the scope of inheritance tax.
Thank you very much, Penny. Well, let's bring in Andrea. Andrea, could you outline what these changes will mean in practice and how they fit into the wider inheritance tax planning landscape?
Yes, of course. The draft legislation published in July this year left many with concerns. In addition to the increased inheritance tax exposure for those inheriting the unused funds, the main practical challenges highlighted were personal representatives being responsible for calculating and paying all of the inheritance tax due, even though they may have no access to those pension funds. Decisions made regarding distribution of the pension funds potentially having an impact on the IHT liability of the free estate, a situation which is likely to be more complex, where pension funds are distributed to different beneficiaries than those named in the will. There's also the existing difficulty of establishing the extent of pension funds to be taxed as part of the estate within the usual 6-month post-death period before interest starts to accrue on the unpaid tax. The changes announced yesterday give personal representatives the power to instruct pension scheme administrators to retain up to 50% of a pension fund for 15 months after death. This provides a practical means to cover potential inheritance tax, interest and costs without forcing personal representatives to find funds elsewhere. And this will be particularly reassuring where the free estate is comprised mainly of illiquid assets, such as the deceased's home. It's not uncommon for individuals to have an unclear picture regarding their own pension funds, and the pensions often come to light several years after death. So the ability for personal representatives to obtain a certificate of discharge and not be liable for inheritance tax due on pensions discovered after they've obtained this certificate is a significant safeguard against unexpected liabilities that may arise later in the administration process.
So it sounds like there are still challenges that individuals are going to need to consider. How can we support them with their estate planning, taking into account the pension changes and the announcements?
Well, we still need to see more detail on the adjustments announced yesterday. These are welcome changes. The 15-month timeframe is limited, and it's likely that personal representatives will still need to be diligent in filing applications promptly for certificates of discharge in order to be suitably protected. For individuals seeking to mitigate their inheritance tax liabilities during lifetime, there's still huge benefit in planning and actively considering the pension position as part of their wider estate and succession plan. So in brief, we would recommend that individuals track their pension funds accurately to allow professional advisors to give reasonable, accurate estimates of inheritance tax exposure and help clients to see the extent of their liability so they can plan for this and plan for how they're going to pay it. This will help the beneficiaries and executors on death engage actively with financial, tax and legal advisors to ensure that a plan considers all potential impacts and meets clients' goals. Alignment of pension planning, including detailed letters of wishes alongside wills and other wider succession plans is key. And once the plan is in place, ensure the pension arrangements are regularly reviewed and restated or updated as appropriate to ensure that any carefully laid plans are more likely to be followed by the pension scheme administrators after death.
So you've highlighted the importance of integrating pensions into estate planning. Ahead of the budget yesterday, many individuals were giving gifts to family members and into trust, in some cases advancing existing estate plans in order to get ahead of the speculated changes to gifting rules. Does lifetime gifting remain part of a comprehensive strategy to manage inheritance tax exposure?
Yeah, absolutely. Lifetime gifting remains a key part of a well-considered planning strategy. The budget didn't introduce any changes to the existing exemptions and reliefs. So the familiar tools such as the use of the annual exemption, small gifts allowances and gifts out of income are still available and should be used. Larger gifts to family members can also reduce the taxable estate if the gift survives 7 years. And taper relief to any tax due continues to apply from 3 years after the gift. So that's all still relevant planning. When combined with pension succession planning, lifetime gifting can help balance liquidity and succession goals. While pensions will now attract inheritance tax from 2027, they still offer flexibility and tax advantages during lifetime. So making gifts of non-pension assets alongside accessing pensions supported by expert financial advice ensures a more rounded approach to reducing exposure and meeting families' objectives. It's also worth highlighting that there have been no announcement at this point in relation to the availability of CGT-free uplift in asset values to the date of a person's death, or the availability of holdover relief for lifetime gifting. With all tax and estate planning, there is a risk introduced if we look at one tax in isolation. And when preparing an integrated plan for clients, we will consider the impact of CGT and other relevant taxes alongside inheritance tax. The fact that these elements remained unchanged allows us to continue planning with lifetime gifting in a similar manner to what has gone before.
Thank you, Andrea. Well, yesterday's budget confirmed the cap on agricultural and business property reliefs announced last year, despite significant lobbying by farming and business groups concerned about the impact of those reliefs. Let's turn to Naomi. Naomi, can you outline what was confirmed and the key change announced yesterday?
Thank you, Joanna. Of course, yes. The main thrust of the changes announced last year was the introduction of an effective £1 million cap on the total value of assets which can qualify for relief at 100% under the combined agricultural property and business reliefs. And that takes effect from the 6th of April 2026. While as a headline this sounds like a simple shift, the change has far-reaching implications for tax due on estates, on lifetime giving, particularly gifting which may fall within 7 years before a death, on qualifying assets held in existing trusts, as well as those assets being transferred into trusts created in future. There are reliefs these are reliefs that attach to agricultural assets or business interests, and there can often be added complexity as a result of the structure of the business itself, and business governance documents may not be fully up to date, may not be adequately drafted to deal effectively with the impact of death of one of the co-owners. This is a case whether the deceased is a partner in a partnership or a shareholder and possibly director too in a corporate business. Estate planning for tax liabilities in an individual's estate will have a wider impact than that estate alone, where we have businesses involved. Even businesses with significant capital value may be comprised of mainly illiquid assets, and any funding for tax needs to be provided in a way that doesn't destabilise that business. Many listening to the budget yesterday will have been disappointed that the value of the allowance level hasn't been increased from the £1 million cap or even scrapped, but there are reasons to be a little more positive as the Chancellor announced that the allowance will now be transferable between spouses and civil partners. And this brings the 100% relief allowance in line with the transferability of the nil rate band and residence nil rate band allowances. Of particular note is that this transferable nature of the relief allowance is stated to apply automatically to those individuals who have inherited qualifying assets from a spouse or civil partner who died before the 6th of April 2026. So the estates of the surviving spouse, which contains qualifying assets, will now be able to claim up to £2 million relief at the 100% rate, irrespective of the value of any qualifying assets in the estate of the first deceased.
So how does this change the outlook for estate planning for those who have assets which may qualify for APR, BPR in their estates?
I think this change provides quite a bit of relief, particularly for those who would only have considered the more complex will structuring for the sole purpose of allowing them to claim the maximum £2 million of relief, but who otherwise wouldn't ideally seek complexity, or those who can't afford to have specialist advice or undertake more detailed estate planning. I think we as a firm think there are still significant advantages to structuring wills in a way which allows for relief claims to be made on first death, although that will be a decision for each couple to make after receiving tailored advice on their particular circumstances. I think key things that we will be considering with our clients are the fact that a claim made on first death will result in HMRC making a decision regarding whether or not the farm or business qualifies, and that outcome could well be informative for the ongoing business owners in future decision making. So for example, if a farming business is considering further diversification, knowing the view of HMRC at the point of death of the first deceased might help them to understand how that diversification will impact on the balance of trading versus investment activity, and therefore whether or not they're likely to still be able to claim BPR at all. But more generally, claiming early allows for relief to be banked and for the assets that have been passed to someone else to be held outside the estate of the surviving spouse. And this is helpful on two main occasions. One where the first and or second estate could be kept below £2 million if it's not amalgamated. So that keeps things under the threshold for claiming residence nil rate band, which will help to improve the tax position, but also where the qualifying assets are likely to be increasing in value significantly in future, or at least at a rate faster than we know the £1 million allowance is going to be increased, which for the time being is not at all until 2031. So I think passing these assets into a trust or outright to a non-spouse beneficiary is still going to prevent that growth being taxed in future as part of the surviving spouse's estate. So there's real merit in discussing this, but it is going to be a personal choice for individuals to make. I think the key message is really that it's very important for those who are affected by changes to APR and BPR to seek advice now, ahead of the tax changes at the start of April, because we still have a window between now and then for additional planning and lifetime giving restructuring of businesses to improve a tax position. I know it feels now like April's still a fair way away, but time is actually short, and planning of this nature is complicated and usually requires specialist valuations. We've already seen in the run-up to the budget this week, with all of the activity of people preparing for the news they anticipated might come, that valuers for land and for businesses have had very little to no capacity to take on new work. And the same has been true for legal and tax advisors. So the message is, don't leave things until March to start asking questions. Now is the time to seek advice. I think another message to take away is that the gifting of business or farming interests is unlikely to be as straightforward as just purely thinking about who you want to pass on capital value to and how tax can be mitigated. Business owners will be keen to ensure that control of the business passes to the right hands to secure the ongoing viability of that business. And I think we would help clients to consider structures such as family investment type corporate structures or limited liability partnerships with clearly defined interests in income, capital, growth and control to help support wider planning goals. We recommend that business owners take this opportunity also to review their business governance documents along with their professional advisors, not just to ensure they're fit for purpose generally, but that they also don't negatively impact for IHT relief qualification. And also that they align really well with clients' wills and any other personal estate structuring that owners might engage with at this time. It's also important to say that in all tax planning, there are wider consequences of the decisions that might be made that are non-tax related. And some of the decisions need to consider protecting assets from non-tax risks. These can include things like relationship breakdown of beneficiaries after receipt of a gift or inheritance. And so we could be looking at protective documents like prenuptial, postnuptial agreements, cohabitation agreements, things like that. But also the impact of wider family dynamics. And I think one of the biggest costs to legacy and estates is the disputes that arise post-death, where plans haven't been well considered and carefully implemented. And this can be particularly challenging if only one of a number of intended beneficiaries from an estate are directly involved in the business. That can be a costly mistake, and I think something that's really important to consider alongside the tax position. I think the key takeaway for me is that business owners, rural landowners and farmers should be seeking advice now, maximising opportunity for tax mitigation ahead of 6th of April. And then in the longer term, business owners really need to start talking about estate planning and succession planning earlier with their advisors, with their families, so that plans can be implemented in lifetime, in good time, with careful handover the value and probably also control to the next generation in a suitably protected manner.
There was a very particular announcement yesterday that relates to inheritance tax for a specific group of individuals, which is going to have a big impact for them. It's an announcement related to the infected blood compensation payments. Can you tell us a little bit about what that's going to mean for the affected?
Absolutely, yes. The Chancellor clarified the position for those who've been left with poor health and shorter life expectancies, and for those who've lost family members as a result of being given infected blood, and confirmed that where compensation is being paid after the death of the infected person, that those payments will be tax-free in the estate from an inheritance tax perspective. And additionally, the first living recipient of the compensation will have a period of 2 years in which to give away some or all of that compensation without IHT consequences. So that's really good news for families who've had a lack of clarity on that so far. Our estate administration specialists are already assisting a number of families who are due to receive compensation under this scheme, and this is very welcome news for them as they work out how best the compensation received can help support them and their families going forward.
Thank you very much, Naomi. Well, there is lots that we've been chewing over, lots to take away from this morning. Let's just go back to Andrea for a final thought. Andrea, what would you say in a nutshell is the key takeaway for high net worth and ultra high net worth individuals and families and those who advise them?
Yeah, definitely lots to consider. The extent
No, I think we have lost Andrea. So we're not going to be able to get Andrea's little final roundup. But I think that the really key takeaway from today is that, as we've been hearing, there are lots of changes. It is important to be aware of those changes that affect you. We're here, our experts are here. If you want to raise any questions in the chat channel, it's a short meeting for us today, so not enough time to answer individual questions right now, but we will be very happy to answer questions after our meeting this morning. Thank you so much for joining us, and we look forward to hearing from you. Have a good day.